I had a dream last night, it was different. It was you and I in faded television. I'm not in love with you, but if I was, here's what I'd do. Here's what I'd do. If I was in love with you, torn up sheets, all the feathers. There's a picket fence somewhere, nothing better, a dose of
So let me give you guys the background story of how I got into this moot. Our university has this overall internal moot competition called Kenyan Moot, where those who participate and stand out are selected for the 7 moots you guys can see on the screen. So for me, due to some circumstances, I was not able to participate in the Kenyan Moot competition, and I remember I felt really bad because I wanted to do the moot and didn't want to start in 3rd year, because in my head I was like, if this is something I'm good at or think I'm good at, then I want to start nurturing my skill as soon as possible. So I was in 2nd year at the time, sorry I forgot to mention. So when I didn't get the chance to participate, I was bummed out, but I tried to see the positive side, and I was like, I'll focus on other stuff like debate, YouTube and stuff like that. But in one of the moots, that is the All Kenyan Moot competition, one of the participants dropped out last minute, and one of my classmates, shout out to George Philip, approached me and informed me of the vacancy. I thought about it for like 5 minutes and was conflicted because it was during exam week and I would be joining the team last minute. That meant I had to do double the work with half the time, and with exams on top of that. But I thought about it and said I would, because this is something I really wanted to do for a while. So later that day I went for the interview, and the coach was really nice actually, so I ended up getting in. Long story short, I ended up getting in. One of the ways I prepared for this moot was sacrifice. So first, like I said, joining the moot last minute meant I had to do twice the work, put in twice the effort, if not more, with literally less than half the time during exams. So I sacrificed a lot. Like in the final part of this video, you'll see clips from the actual moot, and you'll notice I had eye bags, heavy ones. Like I literally sacrificed sleep, time, my mental health. I didn't prioritize all those things, to be very honest. And if you know me personally, you know how much I value those things. So this was actual sacrifice for me. So one of the ways I prepared was sacrifice. The other way I prepared for this moot was I practiced by myself a lot and re-listened to my speech. So I'll insert a few clips of me practicing in school. On this day I had gone to school on a Saturday, because school is always mostly empty on the weekend. So I had this whole classroom to myself. I recorded myself and watched myself multiple times to see what I could improve on.
My lords and ladies, and may it please this honorable court. As earlier introduced, my name is Makena, co-counsel for the petitioners, Secretary Human Rights Commission, and I will be submitting on issue C and issue B. On to issue C. Under this issue, we have 2 submissions to make. The first is that Nobuku's freedom of expression was violated contrary to section 33 of the Constitution of Makena. And the second is that multimedia services freedom of media was violated.
Other than self-practice, I had practice with other guys in the team and with our coaches on a regular, where they give us constructive feedback, which was also really helpful as well.
Liberty means anything. If liberty means anything at all, it means the right to tell people what they may not want to hear. The Honorable Chief Justice, my lords and ladies, and may it please this honorable court, as earlier introduced, my name is Makena, co-counsel for the petitioners, Secretary Human Rights Commission, and I will be submitting on issue C and D. Under issue C, we have 2 submissions to make. The first is that Nobuku's freedom of expression was violated. The second is that multimedia services freedom of media was violated.
Finally, I think it's important to mention that for myself, I used this special method where I wrote myself like a mini script of exactly what I was going to say, since I knew I didn't have enough time before the actual moot competition to grasp all that knowledge, all those cases, etc. And so this script idea really helped me. The images on the screen are from the quote-unquote scripts that I used. The purpose wasn't to read word by word, rather it was to be able to give myself confidence that I had something to say in all the arguments. Like, there's a time I remember I panicked so much during training, I literally used to shake. And on this particular day, I was really unprepared, to be honest, and I was stammering. I couldn't even say anything. I had to stop. So this script idea really helped me because it reassured me that I had things to say and I could always refer to those things and remember in case I forgot. In the end, as you guys will see, at the end, during the final Moot competition, we had flashcards. So I transferred my script in the form of flashcards so that I didn't have a big paper blocking my face so that the judges could see me. And in the end, I literally almost never referred to those flashcards because just having them there reassured me that I did have that knowledge, and it gave me the more confidence to be able to speak more confidently and stuff like that. So I really would advise summarizing everything that you have into sort of like a script in chronological order in a way that you can personally understand, if that is what works for you, because for me that really helped. So I know I could say a lot here. Do your research, practice in front of the mirror, with friends, with coaches, blah, blah, blah. Nothing that you haven't heard already. But if there's one thing I think that just really saved me, or helped me rather, was confidence. I know this sounds so cliche, but trust me, if you take nothing from this video, take that. And I'll explain. I remember our contract law 2 teacher gave us this advice, and I came to apply it in so many other areas in life. During the last class tutorial, she really emphasized on this confidence thing, and in particular, I remember she was like, even if you don't know anything in an exam, write your answers so confidently, phrase them in such a way that shows confidence that even the person marking may be convinced that it is in fact correct. And if you think about it, that can actually happen. And so I decided to take the same advice and apply it here in this mood as well, because I was honestly so scared. But I decided, even on that final day, even if I don't know what I'm saying, I'm not going to show it. I will be confident in my answering of questions, in my submissions, everything. I will. And so if I'm being honest with you guys, I'm rewatching these clips of the final mood right now for the first time, and I'm just realizing now really how well I did. I was so nervous, but I'm so proud of how confident I looked and sounded in those videos. At least to me, like, I just have to give myself a pat on the back, because I think with the little time I had and all those other things happening and being able to do that, like, man, I must I must So guys, confidence, believe in yourself. Seems so simple, but believe in yourself. And even if you don't show it. Believe in yourself so that others won't even have an option. Be confident, your posture, maintain eye contact, and all of that stuff, and everything else will likely fall into place. So yeah, that's the biggest tip I can give to anyone who wants to moot. Honestly, yes, I really overestimated my ability to balance. Usually, I'm able to do that so well with different co-curriculars that do not require as much effort, time, etc. But with this, I think I was so desperate to participate in the moot that I didn't weigh it to the prevailing circumstances at the time. This was last minute, this was a week or so to the oral competition, memorials were not even submitted yet, and it was like almost the deadline, and this is when I'm joining now, same time as exams, same time as some cuts. And in my head, I really thought I could do all these things without I just thought I could do them easily, and I thought I would be able to do all these things by simply sacrificing time and energy. But if I'm being honest, looking back, that was not a wise decision, because I ended up being emotionally drained by the end of it, burnt out, just all those things. And I think what I would do different is that I would wait for the next Hindiwakio competition and just have started from the beginning, being assigned a good partner, having same deadlines, etc. Just all those things that, you know, not during exams time, things like that. Or even if it's during exams time, I've prepared from the beginning. And I think that would have altered my overall mood experience to a better one, if I didn't have the pressure that I did of last minute joining simply because I wanted this experience. And this experience is not like it was going anywhere, it was still going to be there next year, which leads me to my second regret, which is, I think, very important to mention, is that because of the prestige that Moot has, especially in law schools, I felt that if I don't participate in one, then I'm just not good enough. And I just want to say that I regret placing my value in a competition. These things are good and all, but they don't determine your value. At the end of the day, you could be a good mooter and a bad person, and you could be a bad mooter and a good person. And I'd choose any day to place my value on being a good person. Being a good mooter, it's good, I'll try, but if it doesn't work out, I won't lose my value, and I don't want to ever see myself as less of a person if that doesn't work out. And I hope everyone listening to this, all of you aspiring mooters and all of you already mooters, know that your value as a person is not placed in mooting. So yeah, that's the other regrets that I had, that I placed my value in the wrong things. So at the end of the day, I was encouraged that we did reach finals, and for the most part it went well. But in my head, I'm just imagining that if I didn't come to that realization sooner, how broken I would be had it turned out the opposite way, because I'd just be like, I'm not good enough, whatever, just because we didn't do well in a moot competition. And that's crazy. Like, that's not where your value should be placed. So yeah, don't do that, guys. So I'll insert the clip of my submissions during the moot competition, and then a screenshot of special thanks to everyone that was a part of this experience. You guys will notice that I had eye bags in these clips. I didn't sleep the previous night, so yeah. Another disclaimer, I didn't have my spectacles. They had just broken. Okay, they hadn't just broken, they had broken like a few weeks back, but I hadn't gotten a replacement yet. So if you see me squinting, just understand.
Human rights are not something that the government gives to you as a privilege. It is something that is entitled to each and every human being by virtue of them being. Honorable Chief Justice, my lords and ladies, and as earlier introduced, my name is Makena, and I will be submitting on behalf of the petitioners, Kutesa Human Rights Commission. I intend to take 14 minutes of this honorable court's time, and I will now proceed to my argument. My lord, it is our submission under issue C that the state did violate Mbogi Media's services freedom of media. Like I earlier said, these freedoms are not something that the state can just take away with no grounds. In demonstrating this, we will use the Siracusa principles as provided for in the ICCPR, which the state of Mbakni is bound to, as can be seen in paragraph 4 of the fact sheet.
These rights, Council, are they absolute?
My lord, thank you for your question. This freedom of media right is not absolute, as can be seen in Article 34 of the Constitution of Mbakni. However, it can only be limited under grounds provided for in Article 33, Clause 2 of the Constitution of Mbakni. These grounds do not include treason, and those were the grounds that the state used to limit this particular rights. Therefore, it is not justifiable. In fact, in this particular matter, I'd like to refer you to the persuasive case Attorney General and two others, where Honorable Justice Matibo expressly stated that this list, therefore, nothing can be added or introduced to this list. The law is the law. If treason is not amongst that, is not in that list, then it is not in that list, and we cannot use that as a ground to limit this particular right.
It's proportional, though.
We'd like to disagree with respect that it was not proportional, seeing that the state in paragraph 27 shuts down all of the media services when only one news station under the media services was the one that recorded this. And even shutting down, even if they did shut down only this one, it would still not be proportional because it was not legitimate to shut it down in the first place.
Are we bound by Matibo's position? Sit down and explain.
But the Constitution itself, if we do decide not to refer to this particular itself, lays out this particular these particular limitations and the grounds in Article 33.2, they are laid out in a conclusive manner. Therefore, the way they are phrased in that particular article is that they cannot be, they are complete as they are, and that no new rules can be introduced to this particular.
Council, before you move on, about the question of legitimacy of the actions of the government in this case, what is your position about the purported swearing in that took place and the numbers that attended that purported swearing in? And don't you think that it serves a legitimate purpose to the rest of the country not to air such an illegal activity that is happening, and therefore it is a legitimate purpose that the government is trying to achieve by shutting down the media after giving a warning that such actions should not proceed? What is your take on that?
My Lord, thank you for your question, and I would like to respond to that question by beginning to refer you to a case that this same Supreme Court decided in the year 2021. And this was the Communications and 5 others versus Royal Media Services and 5 others, in which it was seen that in paragraph 394, that by when freedom of expression is put to use by the media companies, it acquires a new dimension and becomes freedom of information. Therefore, this particular purpose of the state in limiting this particular treasonous act, if they did intentionally want to limit this treasonous act, then the fight is not with Mbogi Media Services, it is with Mooting and not Mbogi Media Services. It is our submission that by simply adding this particular inauguration ceremony, which we can see as per Section 35 of the Media Act, is legitimate for Mbogi Media Services to do, seeing that they are to air matters of public interest to the citizens and aid them in exercising their freedom of information. They rightfully did so as Mbogi Media Services. My Lord, if you will allow me to proceed in showing you how this particular act is not legitimate, as you have already helped me in demonstrating Article 33, the grounds laid down in Article 33, Clause 2 were not met. The grounds laid for in Article 24(1) of the Constitution of Working, where it is supposed to be proportional to the act, was also not met. And furthermore, this is not even the place of the state to be doing this particular limitation. Article 34, Clause 2.
What are the alternatives? Because proportionality means there are other alternatives. What could the authority have done?
My Lord, it is our submission that there were no less restrictive measures, because we understand that by conceding that there were restrictive measures, then that would mean that Mbogi Media Services did violate this particular right in this instance. The less restrictive measures they could have taken was simply not interfering with this right at all and dealing with Mooting directly, since Mbogi Media Services was simply just broadcasting this particular ceremony. Therefore, they did not take up a treasonous act by simply broadcasting this particular ceremony. If I may continue, in Article 34, Clause 2A, further to show you that this was not a legitimate act by the state, we see that Article 34, 2A provides that the state shall not interfere or control or exercise any authority in regards to what media companies can broadcast. In this particular instance, we see them interfering and exercising control and even going ahead to shut down Mbogi Media Services without proper conduct and without taking proper reasonable, as we see the purpose was not even fulfilled. Article 34.2 Clause B also provides that they are not supposed to penalize any particular persons for what they did in relation to their broadcast. And we can see the government doing that again, contrary to what is provided for in the law. In paragraph 37, when they allegedly order through the Ministry of Information letters for the journalists who had taken part in this particular incident to be sacked, when it is not even in their place to interfere with media matters.
Are you saying that the state has no capacity to shut down the media broadcasting companies if, for example, they are spreading rumors or any other issues which perhaps might injure or rather might be a threat to the security of the state? Are you saying that the state does not have that capacity?
No, my lord. We acknowledge that indeed the state may interfere to the extent where, as outlined in the Kituo Sheria verses that and 33 others verses that versus the Attorney General, it was outlined that the freedoms can be limited by the state to in the regard where they want to protect national security. In this particular instance, this cannot be directly attributed to multimedia services, seeing that multimedia services was not directly linked. In fact, in paragraph 34, as the respondents may argue, you cannot say that this particular riot that came after this particular broadcasting was directly linked to the states, to the multimedia services airing this particular
Councillor, allow me to interrupt you.
Yes,
So are you saying, in fact, that a media company does not have a duty to the state, or to the people, to the citizens, regarding the kind of content that they air? They have no duty whatsoever. As long as they're not involved in the organizing and the planning, they can basically air whatever they want.
That is not our submission. The media does have a duty, and as previously stated, this particular matter is that of public interest. Therefore, by them simply broadcasting this particular matter, they were not contradicting any duty that they had, since they were just simply helping the citizens to exercise their freedom of information while also practicing their freedom of media. And as we can see, also if I may refer you again to paragraph 34, this particular incitement, this particular violent acts that happened in paragraph 34, which is a very important thing to note, is that they were not directly attributed to the media, because they say the situation arose as a result later on, but we can also see that the politicians involved propagated further war between the citizens, and that is what actually led to the looting and the harassment and everything. Therefore, it is our submission that the respondents should not use that as a ground to crucify the media services for simply practicing that freedom of media.
And the unfortunate events that happened to Mwaminifu, how can we attribute it to the state? It isn't known what happened to him. He was just found dead.
My lord, allow me to address that one second issue, which I would like to briefly conclude on.
So when you talk about the limitation of the freedom of the media and the freedom of expression, we also see that actions were taken against Ndovuku, who is the incumbent in this case. And there were actions also taken against the media station. Don't you think there is a balancing of rights here if we go by the pattern that Ndovuku is actually a respondent in this case? Is there a sense of the government trying to balance out those in power and those in the media and those in the opposition, of those who are running against the incumbent, so that we cannot come back and say that the government was discriminatory in the way it tried to enforce the law? What would be your comment on that?
My lord, if I understand you correctly, then it is our submission that Ndovuku's freedom of expression was also not justifiably limited by the state. We see that the grounds they used as per paragraph 24 of the fact sheet were in relation to that he used his freedom of expression to cause hate speech, advocacy of hatred, and vilifying of others. However, it is our submission, as put as a Human Rights Commission, that this particular freedom was not violated, seeing that we have to ask ourselves very fundamental questions. What amounts to hate speech? Section 13(1) of the National Cohesion and Integration Act defines hate speech as any abusive, threatening, and insulting word that is intended to cause ethnic hatred. Whatever Ndovuku says in paragraph 24, none of that can be directly linked to cause ethnic hatred in this particular instance. Therefore, it does not amount to hate speech. Otherwise, every Tom, Dick, and Harry will be using this particular ground. If you have insulted me, then you have used hate speech against me. So therefore, this particular right was also not violated. Was violated with the state. Allow me to now that I have shown you that it was also illegitimate and not necessary, seeing that the purpose was not met and also not proportional, it is our submission that this particular right of media was not justifiably limited by the state. Allow me to now move into issue B, in which I would like to address my lord's question on Mr. Mwaminiku's Mr. Mominitu's death. And we can see that in this particular matter, it is not justifiable by the state, considering that the circumstances in which he died was also not, it is not justifiable generally. However, we cannot, we also agree that until the investigations by the Director of Criminal Investigations are done, we cannot attribute this to enforced disappearance, considering that this particular person involved is unidentified.
Counsel, of guiding this particular court and specifically the bench, what entails enforced disappearance? Because you say that it can't be enforced disappearance, yet Mwaminifu was known as Mwaminifu, and in your statement you bring out the fact that he was unknown. So guide us on that.
Thank you, my lady, for the question. You see, in the fact sheet, you can see that from the fact sheet, we can see that this particular that was seen on the CCTV cameras was just wearing a police uniform, but was not identified. The elements for the enforced disappearance include there has to be an arrest, there has to be a refusal by the state to acknowledge it, that they are taking up investigations, and the person has to be identified as a police officer. In this particular instance, they have not yet been identified, and until the investigations by the Director of Criminal Investigations are done, then we will attribute that to them if indeed this person is a police officer. My lords, I would also like to refer you to the violation of rights as can be seen in paragraph 36 of the fact sheet, in which we see baby Amani's life being arbitrarily taken by the state. The blood of baby Amani, my lords and ladies, is in the hands of the state. This was not justifiable there. We can see in seeing that my time is almost up, my lord, I'd like to request for 2 more minutes to finish my submission.
1.5.
Thank you, my lord. We see that this particular right was not protected, as we see that they have an obligation to protect, as outlined in the Little Bit versus KA case, in which this same court provided for in 2021. Seeing that they did not uphold that right, and also contrary to Article 26 of the Constitution of Makena and Article 6 of the ICCPR, this was not justified. And even if these police officers were acting under instructions, we see that they were, even if they were acting under instructions, we see that the National Police Act under the 6th schedule provides for when force should be used, and this was not used.
Counsel,
Yes,
sorry to interrupt. Are you basing this particular argument on any doctrine? And if there is, could you please guide us on the same?
My lord, on the right limit on this particular violation of the right to life, we are not basing it on any particular doctrine. However, in this, if I understand you correctly, and you mean in regards to the police officers acting on command, even if they were, then this command authority principle that is derived, we like to state advancedly that even if they do state that the Inspector General was the one that issued them the direction, then we completely refuse that. Inspector General should be held accountable for his actions, as can be seen. He was the one that instructed the police officers. My lords and ladies, today we have witnessed a series of injustices, and it is my hope and sincere hope that we will not allow this particular act to continue ongoing. It is in your hands to make these particular changes in favor of the rights and freedoms of the people of Bachelor.
Thank you, Counsel.
Yes, thank you.